Hello, everyone, and welcome to Police Off the Cuff Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD. Folks, we got some movement, some new things occurring in the Idaho 4 case, Brian Kohberger. As you can see the thumbnail up on the screen, Kohberger's attorneys demand evidence be suppressed. The most important bit of evidence that is a huge part of this case and also lays the groundwork for the probable cause that came after the DNA established probable cause was the DNA on the button of the knife sheath, which initially was compared to Brian Kohberger's father, and it was a sufficient match where they then were able to have probable cause to collect Brian Kohberger's DNA and a much clearer match to that. But the argument is also that the way the evidence was obtained, i.e. the DNA, and as you recall, the FBI and the Pennsylvania State Police collected the DNA through going through the garbage at Brian Kohberger's family's Pennsylvania home. Now, legally, once you throw something out, you have no expectation of privacy and no expectation of ownership to that property. So the courts have already ruled on that. So if that's the issue, I don't know if Kohberger's attorneys will in fact have a prayer in regards to suppressing that evidence that was compared against initially the DNA from the knife sheath, from the button on the knife sheath was compared against his father's DNA, which was taken from bottles from the garbage in Pennsylvania. And then, of course, it was compared against the DNA that they collected from Brian Kohberger. The knife sheath DNA, of course, was compared against CODIS. And CODIS is the combined DNA index system. And there are two categories of DNA in CODIS, and one of them is offender. So all of those convicted of certain felonies and certain misdemeanors are in the CODIS database. The second category of DNA is forensic DNA. And that's DNA from crime scenes that has not yet been identified. So we're going to get into that today about the suppression of evidence, and it's known in law enforcement circles and criminal justice circles as the fruits of the poisonous tree, and simply that evidence that is collected unlawfully will be suppressed by the judge, and it's known as the fruits of the poisonous tree. Go back to Adam and Eve, and I'm sure that's where that expression came from. Anyway, folks, hold on to your hats, hold on to your wigs, hold on to your toupee, hold on to your glass of coffee, glass of wine, whatever you're drinking right now. You're about to enter true crime from a police perspective. You're about to enter the off-the-cuff zone, the police off-the-cuff zone.
There has to be some common sense.
They were the ones who called 911 to get him help, and now they're calling for change.
Before we start the show, first, a word from our sponsor. BetOnline is the world's most trusted betting platform and your number one source for online betting. From the earliest odds to in-game live betting, BetOnline provides you with all the action and the ability to watch the games as they happen. With the largest selection of odds on everything from football, NBA and college basketball, NHL to UFC and MMA. Head to BetOnline today to get in on the action with America's most trusted site for online wagering. BetOnline, the game starts here. Joining me today, I know you guys will all be thrilled because he's a fan favorite, is retired NYPD Sergeant, Professor of Criminal Justice at Albertus Magnus College in Connecticut, attorney. Welcome to the show, Professor Mike Geary. Mike, welcome.
Bill, good afternoon. How are you? Thank you for having me on the show.
Doing well, and Mike, I can't think of anyone who's better and more qualified to talk about this topic today than you, because, this whole concept, we learn it as young cops,
Right.
fruits of the poisonous tree. And we are very careful about securing a defendant's rights from the time they're arrested, first of all, before they're arrested, because to arrest someone, you need a legal definition of probable cause, which is facts and circumstances that would allow a reasonable person to believe that a crime has been committed and the person being arrested has committed that crime. So there's a legal definition right there. And an arrest without probable cause is an illegal arrest and will be thrown out. And not only will the case be thrown out, but the police officer, detective, whatever, FBI agent, if they make an arrest without probable cause, is subject to a civil liability, a civil lawsuit. So all of these things you have to be very careful about and very cognizant about as a law enforcement officer. Your thoughts, Mike?
Yeah, Billy, this is the most basic thing when we talked about we talked many times about the Fourth Amendment. You have to have probable cause in order to grab that person and then charge them with the crime. And that probable cause isn't a very high standard. It's not the trial standard of proof beyond a reasonable doubt. It's just a standard that would induce, that, as you said, an ordinary police officer to believe that a person committed the crime. It doesn't matter if the charges are downgraded later on or something else happens, they're found not guilty at trial, whatever. But so long as at the moment that they made the arrest, they had enough evidence to believe that the person committed a crime. We also see that standard, that probable cause standard, when it comes to search warrants and also arrest warrants, because a lot of times, cops in uniform like me would make arrests in person on the street. We don't get a warrant, but other time, like other specialty units like detectives, you've done this a million times. You get the search warrant and the arrest warrant, and that too is also based on probable cause. So everything hinges in this case on whether or not the police had probable cause to believe that Kohberger had been the killer of those 4 innocent children.
100%. And if you do make an arrest or take someone into custody without probable cause, as I said, the arrest will be thrown out, and the person that made that arrest, minus the probable cause, will be subject to a civil lawsuit. And how does that happen very often? No, not really, not very often, because police officers are trained pretty well. It happens, but that's when the line of probable cause is so thin that there's been arrests that as a police sergeant and as a police officer that I walked away from because I didn't think the probable cause was strong enough. And my philosophy was, look, I'm going to protect myself. I'll get him the next time. I'll get him on another day because I don't need an arrest or want an arrest that bad that I'm going to skate the legal liability here of not having solid probable cause. And then we get to the concept of something called fruits of the poisonous tree. And I'll explain it in my simple cop definition, and you can explain it in your lawyer definition. Fruits of the poisonous tree simply means evidence that is collected illegally will be thrown out, suppressed by a judge based on the fact that it was obtained illegally. So what that lead attorney in Kohberger is saying that because the number one piece of evidence here is the DNA on the button of the knife sheath, and that was their probable cause to make an arrest against Kohberger, everything coming after that should be suppressed. Therefore, this whole case should be thrown out. And do I buy that, or will this judge buy that? I cannot see this judge saying, "Oh yes, you're right. I'm going to throw this whole case out." But I think that, as you have said previously, the defense has to start throwing darts at the dartboard, start throwing some mud at the wall, because they have nothing else. Mike.
Yeah, Billy, sort of the fruit of the poison tree, as you say, if there's an initial constitutional violation under the Fourth Amendment, or in terms of Miranda, the Fifth or Sixth Amendment, and if you get statements from that initial violation of the constitutional rights, or you gather some bit of evidence from that initial violation of a Fourth Amendment right under probable cause, then anything further then becomes the fruit of the poison tree. Any other benefit the police get will be examined by a judge at a pretrial hearing, as what is going on in the Kohberger case with the new judge Hippler. And it's called, they're trying to exclude evidence. Ann Taylor is doing the best she can. She's doing what she is supposed to do, zealously advocating for her client. And that is her canon of ethics. She has to do this. And I think we even talked about this a little bit with Matt Murphy last week. He said, you got to do these things as a defense attorney, even if you aren't really sure whether you're going to win these or not. Even if you think that you're not going to win them, you have to do it anyway, because your job demands that you try doing this. And so she's got an uphill battle. One of the things that was really interesting in the Kohberger case was the affidavit in support of the search warrant of his home, and in it said that the last paragraph in the affidavit said, the DNA evidence should not be considered solely the evidence that supports probable cause. That everything else, even if you took out the DNA, everything else by itself would support probable cause and would support the issuance of a search warrant, and that's a good thing. So the DNA was a cherry on top of the sundae, but they had, as the prosecution is going to claim, they already had probable cause to believe he committed these murders, even without the DNA.
Mike, some of the things that, again, I think that Ann Taylor, who's the lead attorney for Brian Kohberger, is really stretching it, because she filed 13 items of evidence she wants suppressed. His Amazon account, his Google account, his Apple, and his AT&T accounts. The video of his car, his cell phone, his genetic information, his father's DNA, evidence from his parents' home to be suppressed. So all of these things, Ann Taylor I don't know if she expects to win a single one of them, but that is what she's asking for right now. The other thing is, and we'll play some of Law and Crime Network, Anjanette Levy, her report from yesterday was pretty good. The defense also objected to a no-knock warrant on Kohberger's parents' home in Pennsylvania. Now, a no-knock warrant is issued by a judge, and I used to remember this in my studying days because of three things, the 3 E's: evidence, destroy evidence, endanger the officers, or escape. If any of those 3 E's exist, a judge will write a no-knock warrant. And I am pretty damn sure that all 3 of those things existed in this case. Evidence, yeah. He was trying to destroy evidence as the officers at the FBI was conducting surveillance. He was washing his car, and he was at 4:00 in the morning, nonetheless, and he was throwing garbage from his parents' garbage pails into his neighbors. As far as escape, the guy's facing the death penalty. I think he would be a danger to escape. And endanger, yeah. He's charged with killing 4 people. You think if he had the chance, he wouldn't take a chance of sticking a knife in an FBI agent or a responding police officer? So those 3 E's, evidence, endanger, escape, surely existed. So I don't know what the point of fighting the no-knock search warrant was, Mike.
Bill, she's trying. She's taken everything she can, thrown it against the wall, and seeing if any of it sticks. And I don't think she realistically looks. This is not her first case. It's not her last. She's a veteran trial attorney. Kohberger won't be her last client. He's not her first client. She knows what she's facing. She knows the odds. the no-knock warrant. Yeah, but a lot of people complain about it, and sometimes rightly so. But you got to look at it from the perspective of the arresting officers. They're facing a young man who's about 27, 28 years old. They believe that he knifed 4 sleeping children ages 20, to death. Just think about how violent an act that is. I think they really are reasonable to believe that he may act violently towards them or try to escape into the woods. What happens if he escapes into the woods with a pistol or a rifle? You're going to have a manhunt. People, you're going to endanger the entire community. Yeah, evidence, as you say, what he was doing with evidence, endangering people's lives. So therefore, what they did was very prudent. And the proof is in the pudding because he did it correctly. Nobody was hurt. They broke down the door and they got him. And of course, they were allowed to search that house looking for anything he might have stashed away. So therefore, it is to me, it is a good no-knock warrant. And I don't think the evidence will be suppressed. But again, she's just doing her job. She's trying her best. And she knows the odds of winning any of these motions are, really, really low.
Absolutely. Angel D from the chat. Compared to some of the recent defense teams in other cases, Brian's defense team are going all out. Looks like they're covering every base. They're a good defense team, in my opinion. I agree.
Yeah.
Look, this is a death penalty case. They have to provide him with a competent, prudent, and strong defense. And if they do nothing, that could be one of his avenues of appeal if he does get convicted. So Angel D, 100% agree. Paige Willow, let's see. Okay, Angel D was. I want to put this up from Law and Crime.
Brian Kohberger, the man accused of murdering 4 University of Idaho students in their home off campus, wants most of the evidence in his case thrown out. I lay out the reasons why Kohberger's lawyers say police violated his rights and how one piece of evidence, if thrown out, could make the entire case against him collapse. Welcome to Crime Fix. I'm Anjanette Levy. Brian Kohberger's trial is scheduled to begin next August, and his attorneys are asking the new judge presiding over his criminal case to throw out most, if not all, of the evidence police have gathered against him. The 13 motions to suppress include his Amazon, Google, Apple, and AT&T accounts, along with the search of his parents' home and his apartment, his car, cell phone, and the genetic information that was gathered on him. There are also new details about the night that Kohberger was arrested included in those motions. I'll get to that and more on the things Kohberger wants Judge Stephen Hippler to suppress shortly. But first, a quick look back at how we got here. Kohberger is charged with murdering Maddie Mogan, Kaylee Gonsalves, Ethan Chapin, and Xana Kernodle in the early morning hours of November 13th, 2022. That's a little more than 2 years ago. He could face the death penalty if convicted, but his lawyers say he's innocent. I was in Moscow after the murders, and I can't overstate just how much this crime affected the community. There was fear. This was a brutal, brutal crime. 4 college kids stabbed to death, some as they slept. More than a month passed without an arrest, and then on December 30th, Latah County Prosecutor Bill Thompson announced that an arrest had been made.
It's sad to be here, but happy to be here at the same time. As Chief Fry indicated, a criminal complaint was filed yesterday here in Latah County, charging the defendant, Mr. Kohberger, with 4 counts of first-degree murder, in addition to felony burglary, which involves entering the residence with the intent to commit the crime of murder.
The cases I cover each day here on Crime Fix show you just how scary the world can be, and one of the scariest things that can happen.
So, Mike, now we have, of course, all of the evidence that they're talking about, but it all stems from what we spoke about before. The fruits of the poisonous tree. So if the one thing that led to probable cause is thrown out, the entire case could be in danger. And of course, the judge knows that. And I don't believe the judge will even consider throwing out the DNA from the knife sheath button. And I think because, first of all, not because it would endanger the whole case. But the fact that it was collected legally, that it was obtained, it was processed, all of those things were done legitimately. So if they weren't, then I would say Judge John Hippler, Hippler, would rule, yeah, I'm throwing out that. But I don't believe that there was any malice in the collection of it or anything wrong that you could invoke the fruits of the poisonous tree doctrine at all.
Yeah, Billy, we've been, police officers, detectives, the FBI, state, federal level, county level, we've been collecting, all kinds of evidence for a century, and DNA for the past 40 years, 35 years in America. And so it's the collection of DNA is very routine. It's done by only particular people. Not every single patrolman is going to be collecting DNA. It's done a particular method. What's new is the analysis of it. You need far less material today to get a DNA profile than you did, say, in 1994. Okay, 30 years ago, much, much less. And so the analysis has become much better, much more accurate, and you need a lot less. And so we're able now to do many other things that we couldn't do before. Figure out family trees. Before it was just like a fingerprint. That's why they call the DNA fingerprinting. Can we match this DNA to something on file in CODIS? Now, not only you can do that, but you could put together, C.C. Moore talked about this, a family tree. So the collection of the DNA should be absolutely no problem. It was done right. They got it at the crime scene, and they compared it to a buccal swab they did after they arrested him. And they already knew that it belonged to someone who was related to the individual, even though they didn't know his name, because they had it from Mr. Kohberger's family. Somebody did a DNA search, that genetic genealogy stuff, 23andMe and all these things that people do. Everybody knows how accurate that is and how amazing it is. So the technology and the analysis in that part of the DNA, question is moved light years ahead of what I did or what you knew about, what I knew about, even a decade ago. So you can argue about whether or not genetic genealogy is accurate or not. You can do that. You're probably not going to win that argument too, because so many people rely on it in terms of looking at populations and genetic mutations and within families, characteristics, and hooking you up to somebody 3 or 4 generations in the past that you didn't even know you were related to. So you can argue all you want about whether, a few skin cells is really enough. But the fact is, it is, because we can analyze that better today than we could 30 years ago. 30 years ago, we needed to actually have blood. Now we can do it with skin cells, just a few skin cells. So it's an amazing technology. It is absolutely proven to be 100% accurate. I don't see where a judge is going to throw out anything to do with the DNA. And if he did, you're still going to try the guy. You've got other, circumstantial evidence of guilt anyway. So, but I don't think it's going to happen.
I don't either. Let me play this again from Angela.
Warrants for Brian Kohberger's cell phone records, and they pulled trash from his parents' home in Pennsylvania, which had his father's DNA in it. And police said that confirmed that Kohberger was their suspect. Kohberger is also asking that all of the evidence seized from his parents' home in Albrightsville, Pennsylvania, be suppressed. Pennsylvania State Police and the FBI descended upon the home in Monroe County in the early morning hours of December 30th, 2022. The operation to arrest Kohberger and then the search of his home effectively shut down the neighborhood for hours. We don't know what law enforcement seized from Kohberger's parents' home, but Kohberger's lawyers argue he has standing to challenge the search, despite the fact that he doesn't own the home. There are a number of reasons why Brian Kohberger's lawyers believe the evidence seized from the home and anything he said should be thrown out. First, Kohberger's lawyers say that federal and Pennsylvania law enforcement violated Mr. Kohberger's Idaho and Pennsylvania constitutional rights by not knocking and announcing their presence and presenting Mr. Kohberger with the opportunity to surrender.
We discussed that before,
Right.
and that's we spent time, the 3 E's.
Right.
And a judge will issue a no-knock search warrant when the 3 E's are present: destroy evidence, endanger the officers, or escape. All the 3 E's existed in this case And that's why I think that argument is just an absolute joke, and she just added it to all the other arguments she's going to make. But it doesn't even make any, to me. Okay, I'm pro prosecution, I'm pro police. It doesn't make any sense to me, and I think the judge will just, sort of, poo-poo. We'll use that word. I think the judge will sort of poo-poo that.
Next, the lawyers say the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Kohberger's lawyers also claim all information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. And finally, Kohberger's lawyers say his...
Just to explain that to you guys, as we said before, because the basis of the probable cause was the DNA on the button of the knife sheath. Therefore, anything else gained or discovered from that piece of evidence should be thrown out. And that's a huge, sort of a huge want for Ann Taylor to expect the court to throw that out. I don't see that happening either.
Statements after his arrest are fruit of the poisonous tree from his illegal arrest and should be suppressed as a Miranda violation. Now, I told you at the time that Kohberger was taken to the Pennsylvania police barracks and initially agreed to talk to detectives, but then he asked for a lawyer. His public defender at the time in Monroe County told me that following the arrest. There were reports at the time as well that when police entered Kohberger's parents' home, that he asked, "Have you arrested anyone else?" I've not been able to confirm that information, but that was reported at the time. This is what Kohberger's lawyers write about the arrest. On December 30th, 2022 at 1:14 a.m. Eastern Daylight Time, Pennsylvania SWAT raided Mr. Kohberger's parents' home. During the raid, law enforcement broke the front door of the home, shattered the sliding glass door of the basement, held the entire family at gunpoint, and seized Mr. Kohberger. Mr. Kohberger made statements to his arresting officers. He was transported to a police station in Stroudsburg, Pennsylvania, and made statements during transport. At the station, Mr. Kohberger was processed during...
I just want to make a couple of points here.
Right.
If during the transport to a police facility, the defendant starts making statements that are unsolicited, they're not in response to questions by detectives or police personnel, then those statements are perfectly good. They will not be suppressed because there is no in-custody interrogation, and that is what Miranda protects against. Was he in custody? Yes. Was he interrogated? No. He was not being interrogated. So he wants to run at the mouth and talk about his third birthday or his 15th birthday, whatever he wants to talk about. The detectives can sit there and listen as long as they don't ask him questions. If he starts saying something like, "Okay, I did it," then they would probably say, "Would you hold off? I need to, before you're going to say anything else, I need to read you your rights." But if he's just spewing at the mouth, telling them information, and they're not questioning him, that's the courts have ruled that's all fair play. Mike?
Yeah, Billy, that's right. So long as the police aren't trying to surreptitiously, get, and I love that word.
We love that word, surreptitiously. On police officer.
I figured I'd work that one in, and they try to get him to actually speak by prompting him in some way. So long as that's not going on, a criminal suspect is always allowed to self-incriminate themselves and say something, no problem. And I was thinking as you were talking, one of the biggest issues that Ann Taylor has, not only is she going to complain about what has gone on, but remember, she's complaining to a Judge Hippler here in Idaho, about about a mistake a judge made by issuing a warrant that wasn't supported by probable cause, 2 years ago in Pennsylvania, and what judge is going to now, in hindsight, rule that what a judge was presented with, earlier was actually wrong and should not have been approved? That's another thing, that a facet of this is that she has to try to climb that hill. I don't think she can do it. I don't think the judge now is going to say at this late date, oh no, that judge, 2 years ago, oh no, he or she didn't know what they were talking about. The police did not have anything close to probable cause. That he or she should never have issued that warrant in the first place. This judge is not going to do that. To tell another judge you were wrong 2 years ago. Not happening. Not happening.
Mike, you're 100% right. That, first of all, that's not in his purview. That's for an appeals court.
Mhm.
He's not going to rule on what another judge, a warrant another judge issued. That's all well and good. If after the trial, if they want to challenge that, that will go to an appeals court. But certainly Judge Hippler from Boise, Idaho, where this case was just moved to, he's not, and he seems, based on what we've seen in the last few weeks, he seems like a no-nonsense judge. Like, let's not reinvent the wheel. Let's not start, as if this case just started yesterday. This case has 2 years of hearings, of arguments. So let's not, reinvent the wheel and start all over again. We have a foundation of which we started from. So I think he's clearly making that point. That's why I think many of these 13 appeals that the defense for Kohberger is making, I think they're sort of not that serious. I mean, they're serious, but I don't think they're going to be approved.
Which police collected information about his person. Finally, during interrogation, before requesting an attorney, Mr. Kohberger made statements to interrogators from the Idaho State Police and the Moscow Police Department. Around the same time, police in Pullman, Washington searched Brian Kohberger's apartment, and Kohberger's attorneys want all of the evidence seized from his home suppressed as well. We know that Kohberger's lawyers have said no DNA from the victims was found there or in his car, but computers and other items were seized, and Kohberger's lawyers say the search of his apartment also violated his rights because of the original investigative genetic genealogy work conducted in the case by the FBI. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. They also write, it is not that the results of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows, two identifications of little to no value. Without IGG, there is no case, no request for his phone records, surveillance of his parents' home, no DNA taken from his driveway in a gated community subject to a refuse removal ordinance. Kohberger also wants the judge to throw out the information law enforcement gathered from a warrant for his Amazon account. The motion says the timeframe March 20th, 2022 through March 30th, 2022, and November 1st, 2022 through December 6th, 2022 were selected. Kohberger is also asking that 3 searches of his Google account be suppressed. His lawyer says the warrant lacked probable cause. Kohberger also wants the search of his cell phone and a 2 terabyte USB drive suppressed. They're also asking to throw out the pen, trap, and trace warrant of Kohberger's cell phone, which allowed law enforcement to track his location. Kohberger also wants all evidence found in the search of his Hyundai Elantra thrown out, along with the searches of his person in Pennsylvania and Idaho, along with a warrant for AT&T. And finally, the defense wants a Franks hearing. That's a special hearing to determine whether police lied in an affidavit in an effort to get a search warrant. I want to bring in Philip Dubé. He works as court-appointed counsel in Los Angeles County.
So, Mike, again, we go back to fruits of the poisonous tree. The poisonous tree is the DNA on the button of the knife sheath. Everything stems from that. Everything grows out from that. So if that was thrown out, there could be a big, big problem with this case. However, that's a huge, huge ask for this judge to find a legal reason to throw that out. And I don't think Judge Hippler, and I know it sounds like the other guy, but it's Hippler, Hippler. I want to make that clear. That would be a huge legal decision. And I don't see a legal reason he'd have to rule that there was no probable cause. I don't see that happening, Mike.
Yeah, Billy, just just take it, in a weird universe that Judge Hippler said, yeah, all the DNA was every bit of DNA, the analysis, the taking of it, the retention of it, the analysis of it, that sort of thing was thrown out. Just say that, just in a fantasy world, they still already had reason to believe that he was the killer because A, they knew it was a white Hyundai Elantra. B, they also knew that it was an out-of-state plate. Okay, so because they could tell from the pictures, the grainy pictures they had, it wasn't an Idaho plate. So they had information about him already. They would have gotten information also. So he is subject to an investigation. Okay, and they realized that someone who lived just over the border in Washington had a white Hyundai Elantra, and the security people, the security police in the University of Washington found out. They matched up the Honda to him and where his residence was. So they had information already. They could still charge him and go ahead with the trial, but of course, they would be in a lot worse position. And maybe the only thing that Ann Taylor could really hope for would be that if she ever in a fantasy world got everything thrown out like she asked for, that they would have to compromise and offer him, say, something like life behind bars without possibility of parole. And then she would try to talk Kohberger into a plea bargain. But this is all fantasy world. This is not going to happen. No way is he ever getting out of prison. Not at all. Not at all.
No, and something. A lot of people, Mike. Some people quite angrily. I'll use the legal term poo-poo again. they'll poo-poo the DNA, the touch DNA, as if it's not legitimate DNA. Of course it's legitimate DNA. The argument that the defense will no doubt use is that could have someone planted it there? Could he have been in that house before? Could someone have just put the sheath there? I mean, it's sort of, in my view, it's sort of nonsensical to suggest that. First of all, what came first, the chicken or the egg? Did the DNA come first and that was unidentified? Yeah, the knife sheath and the DNA was unidentified. Brian Kohberger was identified through that DNA. They didn't know who the perpetrator was, or they didn't have probable cause against anyone. So to suggest that object, that knife sheath, which also to put a nexus between the knife sheath and the knife, granted, that was never found. However, the wounds that were produced on these victims, that were studied by the pathologists, that were all compared during the autopsy, were consistent with a Marine Corps K-bar knife, a very specific type of blade. So that you put a nexus between these things, the connection between what we see on the screen. That's a U.S. Marine Corps K-bar knife, a killing knife that goes back 200 years. Yes, they never recovered that. But the sheath for the knife was recovered. And on that sheath, and you can't see it in this picture, is the button that snaps around the handle of that K-bar knife. And on that button was the DNA that belongs to Brian Kohberger. And for many people that follow this show, many people that follow this case, that's not good enough for them. Oh no. Why didn't they find the knife? Why isn't his blood in the crime scene? Why isn't the blood of the victims inside his car? Why is there no trail of blood? Why aren't his footprints all over? Many, many questions they have. And good. This is the true crime community. Yeah, ask questions. Don't believe us. But we're trying to give it to you from a perspective of first of all, police perspective, and then from the prosecution perspective. And then what the defense is trying to do with this evidence, Mike.
Yeah, Billy, as you and I know, and you know much better than me, they've been using, different DNA analysis since the attacks of September 11th, because of all of the body parts that you and everyone else had to go through. And you're getting body parts and you're taking DNA from them. Sometimes you have a little bit, sometimes you have a lot. Is it contaminated or is it not contaminated? And the ME's office in New York City did an amazing job with you guys recovering all of those body parts and all of the analysis, and they were able to identify the overwhelming majority of all those people who died. There are some who were never identified, but every single person was identified. And so the DNA science of recovery and analysis took a huge step forward. Unfortunately, it was because of the terrorist attacks, but the science moved forward, and it's been proven time and time and time again. And you see these stories on the news about someone, a cold case solved from 30 or 40 years ago with a little bit of touch DNA from a suspect that's developed now, so therefore as even Matt Murphy said, touch DNA is DNA. It's like saying skin cells are skin cells. There's DNA in it. There's DNA in your skin. There's skin cells in your urine, in your blood, in your hair follicle. There's DNA. That's part of what you are. So recovering a little bit here, it doesn't have to be like it was in the late 80s, early 90s, where they need a lot of blood. No, it's just a few skin cells from one of your fingers, from wherever it happens to be. That's good enough. And it has been proven to be accurate to the nth degree for, over and over and over again. So people can poo-poo it, but maybe they just want to believe that there's a that the police conspired to set him up, to flake him for this crime. When you have a local police, the state police, and the FBI all working on this case, that there was a rogue group of detectives that did this. No, absolutely not. No. That's you can believe it if you want, but please, and you can be skeptical. There's nothing wrong with that, but please don't be a DNA analysis and accuracy denier. Please, we know how accurate it is.
Absolutely. Claudia Lanza Stuffer, thank you so much for gifting one police off the cuff membership to a lucky person who is surely waiting to be gifted that. I really appreciate that. Aquarian One, welcome to the Police Off the Cuff family, and a new member. Always welcome to have new members, to have new people search out our brilliance here at Police Off the Cuff Real Crime Stories. Last week we had on Matt Murphy. And, just some of the animus that comes sometimes from the chat. This guy was one of the most brilliant prosecutors in Orange County, California. Had some of the very biggest cases and was undefeated in homicide cases. And you cannot believe some of the vitriol I received about him. Oh, he doesn't know what he's talking about. He's an idiot. He's a moron. Please. The guy's one of the most brilliant prosecutors in the country, and people in the chat are calling him a moron. I'll play a little bit of this. We can hear the moron speak,
Trash away in his neighbor's trash can. I had a next door neighbor who had a 16-year-old daughter who used to have parties every time the parents were home. She would throw away all the booze bottles in my trash can. And I think we all probably did that as teenagers. That's called consciousness of guilt.
Oh my God.
And there's one reason to do that. And that's
Matt, that's a Gearyism. Mike says that all the time. When you said it, I was like, oh, he stole it from you, Mike.
No, he's right. That's why he's a professor. But no, the jury's going to get instructed on that. And there's one reasonable interpretation of that evidence. And if Brian Kohberger is innocent, he's got nothing to worry about unless there's some other crime he's worried about the police getting his DNA on. And then remember, on the cell phone pings, look, he turned his phone off. He was smart enough to know, hey, I shouldn't have my phone pinging near the murder scene at the time, without realizing that it makes him look even worse because he's heading directly towards the murder scene, turns his phone off, again, consciousness of guilt. Like, he brought it with him, so he's smart enough to turn it off, but he was dumb enough not to realize that it should have stayed at home. So, this is probably his first rodeo. He may not have killed anybody before. We're not aware of any time that he has. He's not suspected of anything that I'm aware of. And then remember, there's a lot of evidence in this case we don't know about yet. And we haven't heard anything about what they found on his computers or cell phones. And also then there were some interesting, topics that he wrote about as a grad student, which also arguably are consistent with something like this. So these are all different forms of evidence. I think there's additional stuff we still don't know about. But look, I've got, California prison is filled with people righteously convicted for murders that they actually committed with less evidence than exists in this case. So this is a powerful case, and people can disagree if they want, but I did these exclusively for 17 years as an Orange County DA and 26 years of prosecuting cases, and trust me, this is going to be very powerful when a jury hears this evidence.
Well said. I wrote down 5 pieces of evidence that I think are like you were speaking about. The DNA on the knife sheath, of course, that is the most powerful piece of evidence they have. Although people try to minimize that by saying it's touch DNA, it could have gotten there anyway. Someone could have planted it. They couldn't have planted it because they didn't know who did it.
Don't you hate it? I'm sorry to interrupt. Don't you hate it when your DNA turns up at murder scenes where you never visited? I hate it when that happens.
Rather inconvenient.
Yeah, it happens to me at least twice a week, and I just irks me every time.
Someone flaked this poor guy, as they used to say in New York City. Then we have the vehicle video, which is the route going to, from, and away. The recon. 12 times he reconned 1122 King Road. 12 times. Also, a latent shoe print of a Vans shoe that had triangular shape on the bottom. I don't know if they recovered that shoe to match it up against, because there's something called individual characteristics that they can match up if they, in fact, do find that shoe to match it up. The other thing that no one talks about is the Dylan Mortensen identification of a male fitting Kohberger's description with bushy eyebrows. Dr. Debbie, your thoughts?
My thoughts, I agree with all that's been stated, Sergeant Bill, from Matt, from you, Professor Mike. For me, I'll just kind of sum it up as the top 3 for me as the criminologist. Number 1 is that little 1-inch knife sheath with Brian Kohberger's DNA. Once again, our DNA is nowhere there. The viewers, their DNA. So how and why is his DNA there? Because, he's the one to have participated in this atrocity. And for me, DNA represents DNL, does not lie. So I view it as the silent witness. It says nothing, yet it speaks volumes. So I think that in and of itself is huge. If we look at data analytics, if we look at numerics, we're really talking about numbers that none of us really would have learned in, calculus, high school math, college math. We're talking about the terminology octillion. It's huge.
So Dr. Debbie is basically talking about the strength of the DNA evidence, which is absolutely correct. Initially, I saw ADA Murphy, former Matt Murphy, on television on which was it? News Nation he was on. And this was a year and a half ago. And he was talking about how powerful the evidence is in this case. And I had used that video on one of our shows, and I was like attacked from everywhere. There was arrows coming at me, grenades, everything coming at me, saying, "Oh, that's ridiculous." And this is from, a top prosecutor from Orange County, California. And I feel the same way. I feel that this case is very powerful. The evidence they have in this case is extremely powerful, Mike.
Yeah, Billy, and you go even beyond the DNA and just look at the cell phone the cell phone image, what they got, not even to the messages and the emails or anything like that, but just the pinging. Remember, just in case anybody's not really doesn't remember, the murders occurred after a little bit after 4 o'clock in the morning, that Sunday morning, the 13th of November 2 years ago, his cell phone was turned off at like 2:30 in the morning. It was turned back on about 5 o'clock in the morning in Washington, and then later on, it pinged again right by the tower, right near the address on Kings Road, about 9 o'clock in the morning, 8 o'clock, 9 o'clock in the morning, which is something rather strange. Why would he be there at like 8:30, 9 o'clock in the morning in a location where a quadruple murder happened? You know, and not only that, and there was many people that were coming and going, of course, but match that up with all of the times that he'd been at that time at that location in the area, and his phone was pinging. And I'd like to know the times and the dates to see a pattern. Was it pinging at all hours of the day and night? Were those other pings, those other dozen pings, all late in the evening? You know, so it is kind of coincidental that his phone pings at that location, or a cell tower near that location, at 8:30 in the morning. And we do know that people who are like serial arsonists, serial killers, sometimes they do like to go back to the scene of the crime, especially arsonists, and they like to see their handiwork, and they want to see the ambulances, they want to see people crying, they want to see the police, they want to see all the emergency vehicles, they want to enjoy the havoc that they've created and the fear that they've created. It makes them feel good. They want to see all of that consternation by everyone involved, because it makes them feel like they accomplished something. And that what Matt Murphy said also about, he had studied some interesting subjects in graduate school. He was fascinated by one particular aspect of criminology, and that was serial killers. And he really, and so that goes to what his state of mind was when he was in that one semester in his doctoral program. But yeah, there's so much, even besides the DNA, there's so much other evidence against him. Yeah, it's a good shot that he's going to be convicted.
You know, Mike, what the point you raised about serial killers, and not just serial killers, other murderers will go back to the scene to, for lack of a better term, admire their handiwork.
Yeah.
You know, they're voyeurs to see what was going on at the scene. You know, I used to, when I was in homicide in Manhattan North, I used to take pictures of the crowd.
That's right.
And I did it for twofold reasons. A, the killer could be in the crowd. And later on, when we brought witnesses in, I could show witnesses pictures of the crowd. And if they knew the perpetrator, no one on the street knows anyone's real name. We used to say, you don't know his government name. You know his nickname. Oh, his name is Shorty. His name's Pinky. His name's Paco. His name's Petito, you know. So if you had a picture, go look at this picture of this crowd. Maybe that's him in there, over there, you know, and then you had a starting point, you know. The other thing is taking pictures of the crowd at a homicide scene for witnesses also. Because when you see certain people out there who you know from the community, and you say, I talked to that guy, he told me he was nowhere near that. There he is. He's right in the crowd. Drag his ass in here, you know. And it was a good investigative tool, an investigative resource. So for Brian Kohberger to have gone back to 1122 King Road at 9 o'clock in the morning, there is a certain psychological profile of a killer that does that. And can they use that as evidence? I think they probably will. Yeah. They'll probably say he was back at the scene. And as you say, Mike, ad nauseum, that's his consciousness of guilt. He wanted to go back to that scene to see the chaos that he had created. And it's sort of a sick way to relive a perverse and a horrific experience. But these are the minds of killers, Mike.
Yeah, Billy, this is a signature that we've seen is very common among serial killers and some and arsonists, because and that's what they do. It makes them feel superior because they have created something that ordinary people are reacting to with horror and amazement. And so they get off on the fact that people are like, who could have done this sort of thing. And so it feeds their ego. Remember, he's a very selfish, narcissistic person. He believes he's the smartest person in the room, that he doesn't have anything to learn from people. He wants to teach people. He wants to show people how smart he is. He has to be superior. He was haranguing graduate students within his first 2 weeks of teaching as a teacher assistant in September of 2022. We know that because it was recorded that he had to be spoken to, and he was harassing students, not just teaching, but actually harassing them. So therefore, this is the kind of guy we're dealing with. He made that one huge mistake. He pulled that knife sheath off of the knife and started stabbing. And in the adrenaline rush and the violence that occurred, he was, so focused on killing, he forgot where he put it. And then when he left, he was in probably a hurry to get out of there, and he just was not thinking clearly. He didn't go back and get it. So he made a mistake, and that mistake, thankfully, has led to his arrest. That one mistake, among other things, that one mistake was the biggest one that led to his arrest.
Grateful Glow 1111. But why? How was the knife sheath left? Was it accidental? We believe it was accidental. Yeah.
Yeah.
Let's not forget, he went there, they believe, to kill one person. He did not intend to kill 4 people. So in that horrific scene and situation, yeah, he didn't mean to leave the knife sheath there. He didn't mean to leave anything there. It seems like he took great care to not leave evidence behind. So yes, this was not, he didn't, like some people had suggested, oh, he left it there intentionally to give the police clue. That's television bullshit. He did not leave it there intentionally. That was 100% accidental that he lived there. I always like to mention also, these are the victims: Kaylee Gonsalves, Madison Mogan, Zana Knodel, and Ethan Chapin. We always like to remember that this case is about them and their families. And these are 4 young adults that 2 years ago lost their lives in this horrific situation. And we talk about the case somewhat cavalierly because it does happen to be an interesting case. But again, don't ever forget, in these murder cases, there's real people. Kaylee Gonsalves, Madison Mogan, Zana Knodel, and Ethan Chapin, and all their families. And that's who we should think about. Again, Brian Kohberger is innocent to proven guilty. He will get and is getting a fair trial. And when the case does finally go to trial, they will have assembled a death penalty jury, unless in some way the defense can get the death penalty taken off the table. So far, that has not happened either. So these 13 pieces of evidence they're attempting to get thrown out, it's sort of like a Hail Mary pass. In my humble opinion, it's a Hail Mary pass. I can't wait to read the chat. So you don't know what you're talking about. People were actually calling Matt Murphy stupid. And I was just like, he's stupid. Yeah, he's very stupid. Mike, something? I know you have to teach a class this afternoon. Your final thoughts.
Final thoughts that people should just realize that the police, we're working, local police and Chief Fry and the Moscow PD, we're working with the state police, forensic people. They're working with the FBI. So they had 3 law enforcement agencies working in conjunction together, and they solved this case. People should have no doubt in their minds that Brian Kohberger was identified properly through the proper means and respecting the constitutional rights that he has, and they got him, and they got him right. And have confidence that you're not going to see him walking around anytime free in your lifetime or my lifetime. He's right behind bars where he belongs. Let's tune in and watch the trial, and we'll learn more than we know about all the evidence that they've gathered against him. And so just have faith that the system, it might not be the greatest in the world, but it does work.
Very well said, Mike. And folks, again, if I see some new people here in the chat, if you're not subscribed, just hit that subscribe button on the screen. It's right there. Just click on it. Give us a thumbs up. Hit the like button. Share us with your friends and your family. If you want to contribute to us financially, we have a Patreon with 4 different levels. We also have a YouTube channel membership with 5 different levels, and you can join the Police Off the Cuff family by joining either Patreon or our YouTube channel membership. That's about all we have today, guys. I want to thank everyone for coming by this afternoon. I think it was pretty informative from a perspective of learning about the law, the fruits of the poisonous tree, judges suppressing evidence, things like that, evidence presented, warrants, no-knock search warrants. Remember, what are the 3 E's, guys? I hope you know the answer. I didn't say there was going to be a quiz at the end of this, but remember the 3 E's. You don't remember?
I do.
I got it. I'll ask you the next time.
Okay.
Anyway, I'm Bill Cannon from Police Off the Cuff Real Crime Stories. On behalf of myself and Professor Mike Geary, have a great day, everyone. Thanks for tuning in, and God bless you. One episode